Hello and welcome everyone to today's webinar. Here's your moderator, Bill Gill.
Happy Thursday, everyone. As Mike mentioned, I'm William Gill. I'm ACRO's Director of Government Relations, and it's a pleasure to have all of you with us today for today's webinar presentation titled Disciplinary Notations on Transcripts. Before we get started, I would like to add a quick note on logistics. There will be time for Q&A at the end of the session. We hope to be able to provide about 30 minutes for Q&A. Please type your questions in the chat box, and I will read them aloud for presenters to address at the end of the webinar. Before we start, just want to provide a little bit of background for today. So based on growing interest by ACRO's members, proposed state and federal legislation, and demand for increased accountability of colleges and universities, in April 2016, ACRO's Board of Directors established a Transcript Disciplinary Notations Workgroup. This group, which is comprised of 10 ACRO members who represent diverse institutional types, positions, and geographic location, was chaired by Christy Wold-McCormick, she's the registrar of the University of Colorado at Boulder, and coordinated by ACRO's board board member Laura Medley. Their charge was to develop guidance regarding the use of disciplinary notations on transcripts. They worked diligently through 2016, and in 2017 released a draft report to the membership for input. Additional conversations ensued, and the work group released the final report just recently on June 7th. The recommendations from the work group provide guidance to higher education institutions on how to address disciplinary notations on transcripts and the various options that institutions have at their disposal for notification purposes. Moreover, in addition to attempting to standardize practices on this issue, the work group also strives to promote fairness for all students involved in violations for both victims and offenders. To help us today, we have two individuals who really need no introduction since they are so well known to our membership and have been active ACRO members for many years. First is Christy Wold-McCormick, University Registrar at University of Colorado at Boulder and Chair of the Disciplinary Notations Work Group. Christy has been Registrar at University of Colorado Boulder since June 2014. In her leadership role, she focuses on student privacy, data security, and stewardship, academic policy, scheduling student academic services, academic record exchange and access, staff development, collaboration with communication. She has served on ACRO's Nominations and Election Committee, was chair for an ACRO Professional Activities Committee, and recently was named ACRO's Program Committee. At the regional level, she is a past president of Upper Midwest Association of Collegiate Registrars and Admissions Officers, and currently is an active member of Rocky Mountain Association of Collegiate Registrars and Admissions Officers. We also have Brad Myers. He's a retired university registrar from, as we all know, The Ohio State University, and he's an ACRO consultant. After serving 20 years at the University Registrar, Brad recently retired from The Ohio State University. Within ACRO, Brad served as the president-elect, past president for the association between 2013 and 2016. He previously served on the board of directors as the vice president for records and academic services. Brad has been an author and a member of the editorial board for the 2001, 2006, 2010 ACRO Ferpa guides, and has made over 115 presentations and workshops and sessions at the state, regional, and national level. At this juncture, I will turn over to Christy to start the webinar.
Thank you, Bill, and thank you to everybody for participating today. I am guessing that many of you have either attended a session on this topic at one of the ACRO annual meetings, either this year or last year, or have attended a session similar to those presentations at a state or regional conference. Or possibly you took the opportunity to review the draft guidance document that was released earlier this year. The purpose of today's webinar is to do a high-level overview of the workgroup charge and activity this past year, share a brief history on disciplinary notations, which was studied extensively during the research and writing of the guidance paper, and go through the recommendations of the work group. We'll also learn briefly the action items that the ACRO office has planned since the release of the final guidance report. And we hope to cover the formal portion of our presentation, as Bill mentioned, in about the first half of the webinar, and use the remainder of the time together to discuss recommendations, answer questions of participants, and talk about strategy on how to move forward on our respective campuses. Let's see. Mike, I'm not seeing my little button to advance the slide.
Go ahead, Christy. Tell me to advance, and I can advance them.
Thanks.
And I've got it.
Okay, great. Thank you. So just real quickly, wanted to acknowledge the work group members and thank them again for their dedication and service this past year. We had broad interest when we sought volunteers to serve on this committee, which is a credit to the passion and dedication of ACRO members. The members selected to serve on this task force represented a variety of professionals from different institution types, geographic locations, including states where legislation on this matter was already enacted, as well as higher ed professions. While the guidance document is now considered final, these members continue to volunteer to present and share the recommendations at state and regional, as well as other association conferences. And I'd also like to thank ACRO leadership, including Executive Director Mike Riley and Board Member Laura Medley, for recognizing this as an important and trending topic based on the 2016 annual meeting response, and formulating a charge and support structure for the work group to address this and develop recommendations on behalf of the association. The work group timeline and activities, I want to just briefly share the activities of the work group this past year. After the turnout and feedback from the panel session on this topic at the 2016 annual meeting in Phoenix, the decision was made by ACRO leadership to form a work group. And that took approximately 1 year to execute its charge and write the final paper. This process, as you can see, included monthly meetings, discussions with professionals across our association, as well as sister associations. We conducted research, did a lot of feedback gathering, and participated in many conference presentations where we also solicited feedback and questions during that time. There was a draft document released to members for some initial feedback earlier this year. We took that feedback seriously, considered it, refined, added, modified, enhanced many sections of the report before its final release in June, just a couple weeks ago. Our original charge was to focus on disciplinary notations on transcripts, the concept, the practice, the language, the placement, and alternatives, everything under that umbrella. However, the members of the work group realized quickly that we could not delve into the technical details without addressing the larger philosophical question of whether institutions have the responsibility to notify other institutions of students who pose potential future risks. Our professional field has been somewhat divided on that question over the years, and while not every aspect of the report was supported unanimously by work group members, we did ultimately decide that, generally speaking, institutions do indeed bear that responsibility, though the method of notification doesn't always have to be a transcript notation, and we'll address that in just a little while. Here we go. I am not going to spend a lot of time talking about the history of this topic, but if the history does interest you, there is a section dedicated to it in the final guidance document and report, which can be found on the ACRO website. In our original draft released for member feedback in February, there was a brief historical overview, but after doing more reading and research, I did ask the ACRO office to supply some documents from their archives that dated back to the mid-20th century, and was honestly fascinated to learn that this issue had been consistently addressed by ACRO and registrar professionals since at least the 1950s and possibly earlier. The pendulum has swung on professional support of noting disciplinary actions on transcripts from broad support of this practice through the mid-1960s. And then in the late 60s, early 70s, coincidentally or not, the time during which Ferpa was enacted into law, there was a gradual shift away from promoting this practice of recordation on transcripts. Attempts were made, we discovered, by certain members of ACRO and sister associations in the late 1990s to revert back to support of this practice, but there wasn't a lot of traction or success on those efforts. In the late 20th century and until very recently, 2016, recording disciplinary notations on transcripts was not recommended by ACRO, and this philosophy was adopted by many of its members, understandably so. As you all know, our association's stance officially changed in 2016 when the latest release of the Academic and Transcript Guide published language that disciplinary notations were optional on transcripts. That optional language naturally left many members wondering exactly what this means and what best practices should be advocated on their campuses moving forward. With all of this, I would just want to reiterate that it's important and note the importance that ACRO is not a regulatory body, and its past as well as present recommendations should be viewed as guidance as opposed to requirements for its members and member institutions. I'm now going to turn it over to Brad, who's going to give some updates on some legislation and accountability measures.
Just by way of introduction, I want to go back a couple of slides because we accidentally missed this one. Here were some considerations that the work group took into account as we talked through what are some key questions that we're trying to wrestle with. And those questions provide a sense of foundation for what we were trying to work through in our discussions and what you'll see presented in the final document. So it was worth my going back just to give you that quick list of some of the key things that we were focused on as part of our discussion. Now back on track, I wanted to mention also So I wanted to make sure, sorry for the interruption to everybody in the audience. So let's very briefly go through Ferpa considerations, a question that came up pretty frequently in the course of our discussions. Wanted to make sure that we reinforce that disciplinary records are in fact education records that has been litigated through the federal court system. There are 3 provisions under which you may reasonably share disciplinary information with institutions, with another institution. The first of which is if a student is seeking or intending to enroll or is enrolled at another institution. The second is under the health and safety emergency exception if there is a legitimate threat to the student or other individual, including potentially at another institution, then that information could be shared. And third, which is actually public information, if a student has been found in violation of a crime of violence or a non-forcible sex offense, that is information that can be shared more widely and certainly with another institution. When we solicited member feedback during the course of our discussions, one of the key questions that came up was, well, what about other third parties, so not another higher ed institution? And within Ferpa, I think we want to look at the other third parties in the same way that we would always consider other third parties with reference to sharing educational information. So only when we have the approval of the student, for example, they've submitted a transcript request, having to go to an employer, a prospective employer, or something like that. In other words, we have authorization from the student to be able to move forward with sharing information. Other considerations for the discussion of the work group that we have built into the final report. We acknowledge that there were a lot of different variations of terminology for how people talked about and referred to the status of students with reference to disciplinary situations, and in fact, how they were enrolled or eligible to be enrolled. And so that was something that we wanted to make sure that we talked about, trying to bring some sense of consistency. Insufficient information in notations for those institutions that were already adopting that direction. We obviously don't have a 100% consensus on this issue. For example, several institutions feel that the academic transcript should be strictly focused on academic issues, and some of the other things that are listed there that we took into consideration as part of our discussions. We solicited member feedback extensively during the last year and a half since we started. As Christy mentioned, we have presented extensively at state and regional meetings. There have been a couple of webinars related to this topic. We've had presentations at the annual meeting, at SEM, and have once we released the draft, we received a fair amount of discussion information from various members across the country. and internationally as well, even though some of the FERPA considerations, for example, would only apply to those of us within the United States. Nevertheless, the point being that we solicited, we got a lot of member feedback, and it was very important to the discussion of the work group to take into consideration all of that feedback. We've listed some of the key areas of feedback that we received from the membership, and again, seriously took that into consideration as part of our dialogue. A couple of states have already legislated that some kind of disciplinary information needs to be on the transcript. That is currently true in Virginia and New York. It's come up in a couple of other states and not passed. Still under discussion in some states. And there was also a proposal at the federal level last year to have information included on transcripts going beyond the state consideration and just doing it at a national level, but it didn't get through the legislative process before the end of Congress, and so therefore it died. Whether or not it comes up again is something that William Gill and the folks in the D.C. office will pay close attention to. And with that, I'm going to turn it over to Christy.
Great. Thank you, Brad. Our conversations and research this past year did include reaching out to leadership at sister higher ed associations, including NASPA, which is largely student affairs, the Association for Student Conduct Administrators, the Association for Student Judicial Affairs, ASCA, which is the Student Conduct Administration Association, as well as ATICSA, which is the Association for Title IX Equity Compliance type officers. Both had previously published position statements in recent years in support of disciplinary notations. And in fact, while we were drafting our paper, our final report, ATICSA put out yet another position paper in December of 2016 in favor of the proposed Safe Transfer Act that Brad just mentioned on the last slide, which specifically addressed transcript notations as a means to keep campuses safe and accountable. And so we knew it was important. These other associations were taking measures, writing position papers, that we let them be aware that we were taking a renewed look at this and, where appropriate, if appropriate, collaborate with one another, because we're all serving our campuses with the same end goals in mind, hopefully. The guidance report or document that, again, is out on the ACRA website. Hopefully you all received the email about it. It's quite extensive, quite comprehensive, but it is comprised of several different sections. So there's a brief overview. You can read the brief executive summary for a high-level overview of our recommendations, or you can read specific sections or the document in its entirety. Again, there's quite an extensive historical background if you want to read more about that. For schools that choose alternative means to transcript notations, there are sections focused on that as well. So we hope that members will find it, even though it's lengthy, that it's broken down in such a way that you can focus your attention on the areas that are of most concern or kind of that you have burning questions about on your campuses. And with that, we are going to cover the key recommendations that are listed in the final report. The first recommendation goes back to the earlier slide on the work group's focus and conclusion that we feel that we as campuses do bear the responsibility to send some sort of notification to receiving institutions where a student who is a potential risk seeks or intends to transfer. In the paper, we acknowledge that other institutions are not the only receivers of student transcripts, and if noting actions on transcripts is of particular concern to sending institutions, alternate means of notification are provided in that document, and so we'd hope that you would pay close attention to that, but ultimately that we do feel that we have that responsibility to relay that information to receiving institutions. Brad?
Here's an example where the work group did not reach 100% consensus that the transcript was the only place to put this kind of information, or an absolute place to put this information. But because the consensus, the full consensus of the work group was that it was appropriate to try to provide that information to a receiving institution, the clear majority of the group felt that the transcript was an appropriate place to put it and not necessarily the sole place to put it. But for those institutions that would choose to move in this direction, the consensus of the group was it was an option to consider because the seriousness of certain circumstances were such that the student would be separated from the institution, and that made it rise to the level where we thought that it was appropriate to put it on a transcript.
All right, key recommendation number 3. The work group felt it was an important realization that not every institution would want to, choose to, or even be permitted to place notation on some transcripts based on institutional policies, sometimes statewide or system policies or regulations. Yet, in the spirit of upholding the philosophy that it's our responsibility to notify receiving institutions of potential high-risk students, alternative methods of notification beyond the transcript need to be included in the report. These alternative notifications could include, but are not limited to, a supplementary document produced either by the registrar or a student conduct office that accompanies a transcript. This could be triggered by some sort of a system flag that would either let the transcript processor or some automated process that would produce that type of supplementary document. It could be a notification to a sending institution's conduct office by the transcript processor where transcripts of suspended students are being sent so that they can follow up, the conduct officers can follow up with receiving institutions based on the unique circumstances of an individual student's case. So that in this way, it's some internal business process that the transcript processor would see that a student's requesting a transcript, they have some kind of a flag or hold, they notify the conduct office that carries the baton from that point on. Another option would be having just a routine cover document that accompanies all transcript requests. It could be called a dean certification letter or something similar that would go, again, with all transcript requests to other institutions at least, that indicate the current status of a student, whether they're in good standing, if they have a disciplinary standing, or some other means. There may be other alternative notifications as well, but we wanted to offer up a few examples for campuses to consider if they are thinking of an alternative instead of an actual transcript notation.
The consensus of our group was that if the circumstances were serious enough to separate the student from the institution, then that would be appropriate for a transcript. But if the student was on some form of disciplinary probation or warning, that we did not feel that that rose to the level of being appropriate for recognized on an official transcript.
All right. This recommendation, again, it's truly a recommendation that we align ourselves in our practices as closely as possible in our use of standardized terms and definitions for various student sanctions and penalties. Separations generally are denoted by commonly used and understood language, but not all the time. And we talked about, I think broadly, we are of the understanding that expulsion means a permanent separation from the institution. Dismissal, generally speaking, institutions that used it said they intend for it to be a permanent separation. Sometimes they used expulsion for student conduct that was behavioral in nature, where they used dismissal when it was academic in nature. But we did find instances where dismissal might have been used for temporary suspensions as well. Whereas the term suspension really typically does mean a temporary separation for a specific period of time with the option of a possible future return. We do realize that some schools maybe have policies that use different terminology. Again, we're not saying you can't use that, but we think it would be a benefit to the profession and all institutions where students are transferring back and forth between from if we try to become a little bit more consistent in our standardized use of terms and definitions.
Along those lines, we thought for consistency reasons to provide certain standards of recommended approaches to language that you could use at your institution to provide some consistency for offices that are reading the transcript that might have this information. So for example, we feel that it should be very clear on a transcript whether it's an academic or a behavior or a non-academic suspension or dismissal. It would be helpful to know, especially if there's any follow-up or conversation involved, to know the source of that decision. So is it the student conduct office? Is it perhaps academic affairs? But noting that within the notation would be helpful to the reader and the receiver. Likewise, particularly for the suspension, since we just mentioned that our recommendation is to try to have that referring to a specific period of time. So for example, a student might be suspended for a year, and then barring any other unforeseen circumstances, the student is eligible to return. So putting that notation as part of the transcript notation would be helpful to a reader to know that the student in general is eligible to return in a year.
Key recommendation number 7, the hold doesn't need to prevent the institution. Well, we talked about having, institutions may record a pending conduct statement on transcripts while an investigation is or hearing is planned or underway. We did recommend that students or institutions also consider the use of a block or some kind of a hold to prevent the release of a transcript until the investigation concludes, because that way a transcript may not be released necessarily that has a notation on it until the matter is concluded. However, we felt the hold doesn't need to prevent the institution necessarily from sending a transcript. It would just prevent an automatic release of it. In other words, the student through the hold may be instructed to contact the Office of the Registrar for options or with questions. If the institution decides that while a case is pending or being investigated that they want to release a transcript, the important key here is that they have some system or business process to make note that a transcript has been released so that when the investigation has concluded, they can do the necessary follow-up with the receiving institution if a sanction was applied to a student, or letting them know that the student has been cleared, there's no concerns, or by sending an updated transcript that shows either there is a sanction or there's not a sanction. So that, we know that some of the state legislation recommended that's currently enacted talks about pending conduct, but we wanted to provide that as an option, but also alternatives to that pending conduct as well.
Key recommendation number 8. This is a similar area where the student may be withdrawing from the institution while an investigation is underway. We know that some institutions would prevent that from happening, but the timing may be such that in some cases the student withdraws really before the process has actually started. And so in a parallel fashion to the last slide, we wanted to acknowledge that the individual institution has some flexibility to decide how they want to work with the withdrawal status or capability of a student who may be in the course of working through the disciplinary process. And you may also want to, as an institution, consider using a hold to try to help manage that process under these circumstances as well.
Recommendation 9. This one, again, is strictly a recommendation, but we know it's somewhat dependent on the SIS transcript setup options. We do recommend that the notations go at the end of the semester term in which the sanction occurs, and that transcript legends and keys offer further explanation as needed and provide the reader with instructions on where they can obtain additional information if they have questions about what a particular sanction means or how it applies to a particular student. The primary area of concern here is that it's in an obvious and recognizable location for receiving institutions, so it's less likely to be overlooked. One of the concerns expressed by admission officers on the committee was that, what's their liability if they miss the notation if it's placed on a transcript. And so that's where our goal with this one is that consistency will help prevent some of those oversights. If it can't be placed at the end of the term in which a sanction was applied, that it be in a consistent and obvious location elsewhere, such as at the top of a transcript. We also, in the full report, addressed electronic data exchange so that if an institution employs those non-traditional means as opposed to paper or PDF electronic transmissions, that this kind of hold or flag or notation doesn't get overlooked. And so if you are an institution that does electronic data exchange, you can find that particular example and section in the full report.
Key recommendation number 10, we wanted to make sure that we were looking for a good balance between recognizing student rights and considerations with institutional considerations. So we wanted to reinforce a few things in the report that we feel it's very important at the institutional level that they have a clear code of student conduct so that students have a good sense of expectations about their behavior while they're enrolled, that if a student is engaged in some kind of disciplinary process, that there's appropriate notifications for them so that there aren't surprises for the students, that we want due process consideration not in a formal legal perspective, but at least that there is a good sense of notification and support process opportunities for the student during the course of a disciplinary process. And we think it's also important to be able to have some type of option for an appeal review if the student feels that at the first, maybe even second level of review that they haven't had their rights adequately taken into consideration, and that they have a clear understanding of what would happen from a transcripting perspective. So if a student is found in violation and the institution has adopted putting notations on the transcript, that should be a clear part of the notification going to the student about the decision of the institution and how that gets implemented moving forward.
And finally, our last recommendation is that educational institutions that receive transcripts have comprehensive and consistent procedures to handle those applicants. That we really felt strongly that institutions not apply negative consequences to students whose records have those notations without getting additional information. We do recognize that NACYAC, our sister association on the admissions side that is focused on recruitment and so forth, is really looking at the related but separate beyond the box application discussion. And it is a recommendation that ACRO either collaborate with NACYAC or form a future initiative to address this other side of the topic, that being best practices for admission officers at institutions that receive transcripts with potentially disciplinary notations. While our work group discussed that aspect to some extent, we do know it was beyond our specific charge, so we wanted to stay within scope. Rather, we chose to focus on the development of the comprehensive institutional policies, procedures that Brad just mentioned. And also, because of inconsistencies in conduct standards, sanctions, notation terminologies, notation removal practices used by campuses currently, that receiving institutions don't have that practice of automatically denying applicants that have notations. Rather, we want them to solicit additional information and make holistic decisions based on fit, potential risk, services that they can offer to the students, and possible conditions that they want to impose on students in order to keep both their campuses safe, yet afford students opportunities as appropriate. So those are the basic key 11 recommendations that were rendered by the work group. As mentioned, many more details, rationale, and examples are provided in the full report. But at this time, I'm going to turn it over to William Gill from the ACRO office to provide updates and next steps from an ACRO and government relations perspective, so you can see where we're taking this next.
First of all, thank you, Christy and Brad, and really the entire work group for all their commitment and work. I mean, it's the work group provides some tremendous guidance to higher education institutions on how to address disciplinary notations on transcripts and really all the various options that institutions have at their disposal for notification purposes. I'd really like to also piggyback on Michael's comment in the chat room for folks to really start thinking about some of the questions and start typing some questions for us for the Q&A section. We want to have as much time available for that. So I'm going to go this really quickly. Again, this document is extremely helpful. There's been a lot of questions about how to do disciplinary notations and notification issues, and so ACRO coming out and putting a statement on it is extremely important, especially when it comes down to government relations work. So the couple of things that we're going to be doing is obviously we are sharing the report with our higher education sister organizations, and we will also be meeting with folks who have direct jurisdiction over higher education issues on both the House and Senate, especially as we start beginning conversations regarding HEA reauthorization. So we'll be meeting specifically with some of the members of the House Higher Education Subcommittee and the Senate Help Committee. And so just to provide them the document as well as our recommendations. And I am specifically going to reach out to Congresswoman Spears' office, who really was the member who introduced legislation last year at the end of last Congress that would have mandated the disciplinary notations be placed on the transcript. As Brad mentioned, it died of last Congress, and we actually met with her earlier this year, and she, her folks basically stated that they purposely dropped the bill at the end of the Congress, knowing that it wouldn't necessarily go anywhere, but really they wanted to set up a weather balloon and start a dialogue around this issue as they started heading to this new Congress and HEA reauthorization. So I know they were extremely interested in what the recommendations were going to be, and I think they'll be pleasantly surprised with the options that we are providing, and because their focus really was just on sexual assault on campus, but our report really is focusing on much larger issues than just sexual assault. And really, what we're going to be using this document for is to make sure that the higher education community and elected officials are aware of the report and its recommendations, and at the end that they see ACRO as a resource for feedback on possible legislative language mandating notifications between institutions when an individual is expelled for severe behavioral misconduct. And so that's one of the resources that we want to have members of Congress and see ACRO as, and as a result, already through this Congress, we've had about 15 pieces of legislation that folks have sent over to our office that we have then shared with the public policy, the action group, advisory group, and the PPEG, just to provide feedback and prospective legislation. And we want to be part of the discussion with anything that has to do with disciplinary notations and possible locations of how universities notify one another. So with that, we'll open up to some questions. Quick thing, while we wait for a couple questions to come in, I would like to share some further information. Like all of our webinars, this presentation will be archived and will be found on our site, acro.org. And we obviously provide additional professional development opportunities through meetings held throughout the year. Visit our webpage. So our first question is from Mary Beth. How long do institutions typically leave sanctions on the transcript?
And thanks, Mary Beth. This is Christy, and I will take this first question. I can't speak to current practices of every institution, but our recommended practice is that with suspensions, again, using consistent terminology, are for a definite period of time, whereas expulsions typically are permanent. Because expulsions are permanent and usually reserved for the most serious of violations, those might not need to ever come off. However, we do address some unique circumstances. For example, if a student was suspended a few decades ago for something that was a standard conduct expectation of the institution at that time, but now they've relaxed that and that's no longer a standard. In cases like that, perhaps that expulsion could be removed. But generally speaking, we do advocate that suspension notations not be permanent. The period of time that a student is separated or excluded from campus is typically 1 year, 3 years, something to that effect. And that we do advocate that institutions develop a process by which, after that period of time has lapsed, they either automatically remove that notation. That could be coordinating some business process between the registrar's office and the student conduct office. That is the case at my institution. Or if in the case where a student is expected to complete certain conditions before that be removed, we understand that that might be appropriate in some cases, but that should be abundantly clear to the student at the time that they are suspended, as well as when their suspension period is up, of what they need to do to clear their record. And we do feel that's an important option even for students that don't return to your institution, because many of the times these students might want to transfer elsewhere, and if they've done their time, taking care of those conditions, that those records should be cleared at that point of time. So in terms of the notation retention, we do address that pretty extensively in the document. And again, for suspensions, we recommend that there is a business process in place to have those removed.
Okay, this is Brad. I think that building on Christy's comments, an example for a student who is suspended but maybe has some additional counseling expectations that may play into whether it's automatic or not. But I would encourage institutions, as they think about these strategies and their policies, that they try to look at it from a student perspective. So for example, I would mention that at our institution, when we originally started to put notations on transcript, we expected the student under a suspension to bring it to our attention to have it removed. And I think that, a year later or something, the student often isn't focused on that and doesn't necessarily realize that it's still on his or her transcript until they do something about it. And so you may want to look at it from a student perspective. That may be a good example where it makes more sense to have it be automatically removed if the specific period of time is over. It's a little bit harder conversation at the institutional level to decide if there are circumstances that are unique enough to remove a suspension, or a dismissal or expulsion, because that rose to a very different level of behavioral expectation.
Okay. The next question comes from Tracy. If a student satisfies requirements set forth after being found guilty on a disciplinary behavior, for example, theft on campus, would it be appropriate to remove disciplinary sanction from transcript? I know, Brad, you kind of just covered that, but I think this is more specific regarding the specific situation.
I do agree that it's up to the individual institution to decide. If it's a suspension, I think that we covered that pretty clearly. If it's a dismissal or an expulsion, which rises to a different level, a little more conversation at the institutional level from a policy perspective on what needs to happen, if anything, for a student to raise that back to the attention of the institution for consideration. I don't think there's a clear answer on that. It really is an institutional discretion question.
Okay. So from Mickey, we have a question of, if an institution seeks or considers additional information, quote unquote, when there is disciplinary action, what exactly can the institution that put the comment on reveal? Wouldn't that be a Ferpa protected information?
So I can start with this one, and Brad can sure jump in, that disciplinary records are part of a student's education record, and Ferpa does allow us to share education record information with other institutions where a student seeks or intends to enroll. So if a student has made application to another institution, that institution follows back up with us. typically our office, like the Office of the Registrar, would not have the specifics of the case. We would refer that to our Student Conduct Office, who would use their discretion on revealing what they think is appropriate in order to help that institution make an admission decision based on as much information without maybe revealing everything that they don't need to. And that would be really up to our Student Conduct Office how much they want to reveal. But generally speaking, under Ferpa, we are allowed to provide that information to a receiving institution.
And this is Brad. As noted in the discussion earlier, we recommended from the work group a set of examples of things that we would include within that notation, but the details kind of at the next level of detail beyond which office imposed the sanctions and that the student had been dismissed or suspended, we would not recommend going beyond that. But because you have the contact information or you know which office to try to reach out to, you can follow up if you need to, or if you feel that you need to reach out to the appropriate office on the sending institution's campus to get additional details for you to help make an informed decision. But we agree that you wouldn't want to put those kind of details on the transcript itself.
Thanks, Brad and Christy, on that question. The next question comes from Victor, and he asks, if a student disputes the disciplinary action and under Ferpa requests that they be allowed to insert their own objection or information, how will that be addressed regarding the notation?
So I would suggest that when a student objects via Ferpa to a record, it's because they're basically saying that the record is incorrect. You can't really use Ferpa to say, I don't agree with the decision. You're basically trying to correct the record, not revisit whether there was an appropriate decision made. And so that may not seem like it's a big distinction, but it's a pretty significant line to say that the institutional decision process is not what the recordation question that's being raised by the student. Certainly if a student feels that there's an incorrect record, they can raise that to the attention of the registrar or other appropriate people at the institution. But if they really just don't agree with the decision, that's why we think that there should be some type of an appellate process within the institution for the student to raise that question. They may run out of appeals at some point and still not agree with the decision, but that could be true about a number of things within the higher education setting, not just the disciplinary question.
Okay, thanks, Brad. This one's to the larger working group. Did the work group, and this comes from Daniel. Daniel asked, did the work group discuss to the level of detail on the infraction that should be provided to another institution? For example, he's thinking of a transcript station that was dismissed, i.e. for non-academic purposes, and the school calls to try to get additional information on what that non-academic infraction was.
I think that kind of ties back to Mickey's question that, we as registrars wouldn't make that determination. That would be up to the Student Conduct Office, and they certainly will reveal, I think, enough information that they think is appropriate to that institution. Doesn't say they have to provide every detail possible, but enough to give that institution enough information to make a holistic decision. And, one of the things in our report is that recommendations is that, the receiving institutions form some kind of consistent, group or body that reviews these. It's not always going to, should it always come down to an admission officer. Perhaps the admission office in collaboration with their student conduct office, with their police force, with their counseling staff, for example, would want to review these particular applicants to make a determination if they would be a good fit at that particular receiving institution. So, yeah, we recommend, as Brad said, not to provide too much detail, but enough detail that would trigger some questions that that institution that received the transcript could reach back out to the sending institution for more information as appropriate.
That's a really good institutional campus discussion, particularly led by typically the student life, student conduct, Title IX folks, making sure that perhaps legal affairs or other folks are part of the conversation. I think that the fact that the trigger is coming from the registrar's office typically on the transcript under these circumstances, then having them be part of the conversation is appropriate, even if we in the registrar's office wouldn't be the ones that are passing along the additional information. The fact that those other bodies have had this discussion and all feel a strong consensus to have this on the transcript means that they've had that dialogue, and I think that it's an important dialogue to have on your campus about what kind of information is appropriate to be able to share so that informed decisions can be made at the receiving institution.
The next question comes from Darla, and she's asking if a student has a notation removed after a certain length of time, wouldn't ACRA want to also recommend that the information be still retained in the student information system so that if a reoccurrence happens, then the history is there for the institution to refer to, and the next suspension might be for a longer period of time or just flat-out expulsion?
Absolutely. So I'll take that one. And we didn't specifically address that. That is in the current recommendation in the Academic Record and Transcript Guide, that it's essential to keep this information and have this information in the database. So our focus is more on the transcript. So absolutely, we agree with that, and it should always be retained in the system. And whether it's the SIS or if it's the Student Conduct Office's system, some place that is responsible for managing and monitoring that would have that whole history. So our recommendation really deals with the transcript notation and or other kind of notifications to receiving institutions. But definitely that should be retained for future reference as well as for repeat offenses.
Okay, the next question comes from Joanna. It's really regarding non-higher education institutions. So the question is, how do these recommendations apply to sending transcripts to organizations that support professional development, for example, law, medicine, pharmacy? They're not actual institutions of higher education, but kind of a third party.
I'll take that one. The group did talk about, were there enough significant differences between sending to specifically another higher institution or a third party that the group would want to recommend differentiating transcript directions? So recommendation A, if it's going to a higher ed institution, then put it on the transcript. Or option B, if you know that it's not going to a higher education institution, then don't put the disciplinary notation on the transcript. And we did not feel that that was a recommendation that we wanted to make, that the transcript was really a holistic document. We weren't trying to differentiate it from that perspective. And I think that for the professional references that are specifically in the question, regardless of the transcript in and of itself, I think most professional groups are going to ask disciplinary status, good standing status kind of questions before they're going to certify eligibility to be considered in a professional licensure situation, in addition to whatever they're going to read on a transcript anyway. I'm an attorney, and I know that my evaluation process as part of becoming an attorney went beyond just simply reading a transcript and whatever might have been on there as far as my eligibility to be able to serve within the profession, and I think that that's fairly typical for professional considerations. But we did not recommend that you would try to have a differentiation on the transcript itself. So again, if there was a notation on the transcript, it's a notation on the transcript regardless of who is reading it.
And we did address, so we felt if institutions felt strongly about non-institutional receivers receiving that information, such as employers or other types of organizations, they might be better candidates for those alternative means of notification. Then they can have institutional policies of which other receivers which of all the receiver, whether it's an institution or another third party, would get that alternative notification or supplement document. That would be an internal business practice.
So just to summarize, Christine, Brad, so you guys, the group did not differentiate between institutions and third parties, and if an institution so chooses to place the disciplinary notation on a transcript, then that's certainly fine. But if they do have issues about sharing disciplinary transcripts with disciplinary notations on them, that therefore some of the other forms of notification would be a good option for that institution.
Agree.
Yes.
Right. Because we had a couple questions all lumped up together regarding the third-party notification. From Laura, she asked, some schools only request dean certifications for most recent institutions of enrollment. Therefore, what would you say is the obligation of the institution that a student is transferring to seek information about prior misconduct of all prior institutions if those institutions do not provide transcript notations?
I'm just reading it again here myself.
So essentially the question is, because the receiving institution might naturally reach out to a sending institution, but not typically to multiple iterations of a previously attended institution. They're typically reaching out only to the most recently attended institution, particularly if they weren't looking at a transcript notation. Did the group talk about recommending reaching out, all along the trail of institutions for dean certification or some other notification beyond the transcript? Or at least that's how I'm reading the question. And I don't think the work group ever really talked about that specific issue.
Yeah, I think there's the assumption that the prior institution probably would have done its, diligence in terms of it receiving or accepting that institution. But most institutions would require transcripts of all prior institutions, so that if there's something that's still active at an institution 2 back, say, for example, but the most recent institution didn't stop that from admitting that student, the final institution could still act on it if they so chose.
Whether that means they also ask for a certification letter or something in addition to a transcript would probably be an institutional question. But again, the work group didn't specifically ask that question within our work group discussion.
And looking at some of the questions coming in, I do want to just reinforce with the employers and so forth that we never advocated that institutions provide 2 different types of transcripts, one for employers and one for receiving institutions. That, going back to Brad's point, the transcript's the transcript, and we wouldn't want an institution to bear that burden of having to differentiate. But if that was a real concern to them, that they look at one of those alternate methods.
And Krista, just to piggyback on that, to confirm that there's also no issues regarding Ferpa sharing that information.
Well, there would be from the perspective of, for the sake of argument, let's say that an institution put a disciplinary notation on a transcript. If that transcript went to a receiving institution of higher education, they have the flexibility of having the conversation. If they sent it to a prospective employer without permission of the student, they couldn't then call the institution or contact the institution and get additional details. They would really need to get a student's permission to have the conversation in more detail about whatever that disciplinary issue might have been. And if that's important to the prospective employer, then that would be a conversation that they would want to have with the prospective employee. There's that exception within Ferpa related to another higher ed institution that does not apply to a prospective employer or other third parties. So
I think that's a perfect segue to wrap things up. We are at 3:01 in the afternoon, and we want to be conscious of everybody's time. I think we've answered everybody's questions, and we gave a good 20 minutes of questions. So really want to thank Christy and Brad for being with us this afternoon, and really everyone who attended. We nearly had almost 200 folks on the webinar today. A special thanks to the work group, especially Christy, Brad, and Laura for their efforts and insights on this important issue. We hope that you enjoyed today's webinar and are able to join us for future ones. Again, thanks everybody for joining, Brad and Christy, and everybody have a great Thursday.
Thank you.
Thank you.
Thanks, everyone.